Mr. Lewis. Mr. Garcia, come up, please, sir. Mr. Garcia, you tested positive for marijuana, amphetamines, methamphetamines, and ecstasy. Did you drive here? Oh, you're surprised about the ecstasy?
Yeah, I'm surprised about that.
Wow.
I did smoking. I did relapse a few days ago.
Yeah. All right, so I'm going to find, obviously, that is a violation of your bond conditions. I also told you last week specifically that you had to be here on time. No, you were not here. And so I'm going to raise your bond in your case to $100,000. If you make that bond, a condition of it is that you have a drug patch on at all times, that you also have a GPS monitoring device and remain in Jefferson County since you can't seem to get here on time. We'll figure that out. Talk to your attorney. You can go back with the bailiff. Himmler on Jason Harris. All right, Mr. Harris, this is 24 DCCR 2254. You tested positive this morning for methamphetamines and amphetamines.
I drink a lot of 5 hour powers for 3 days, and that's the only thing I think that would make a problem. I've been in Houston with my kids, and I ain't even been around here right now. And I drink a lot of 5 hour powers regularly.
5 hour powers is not going to test positive for methamphetamine.
You know, if you send it off to the lab, I'm sure you'll see that it's not, I don't do nothing like that. I don't have the money for that.
Well, all I know is you tested positive for methamphetamine. And obviously there's some concern because you were arrested while this case was pending, and Mr. Coleman figured that out. Hold on.
So it was a traffic ticket.
Just hold on.
I would just observe this, if it's paraphernalia, that's a class C and normally those aren't arrestable. I mean, it is an arrestable offense, but normally it's just a ticket. So jail or fine on the offense.
Doesn't matter. If you're on bond for a felony, you should. I just asked you not to say anything else right now, okay? I'm just checking on something.
Let her check it.
Obviously, Google and AI is not the end-all be-all, but it is unlikely to cause a positive result on a standard drug test. A 5 hour energy drink does not contain prohibited substance like THC, opiates, or amphetamines. Extremely rare and undetected issues involving cross-contamination during manufacturing would do it, so I don't think that's what we're worried about today. I'm going to grant the state's motion to raise your bond based on the fact that you tested positive, based on the fact that there was an additional arrest while you were on bond for a felony offense. I'm raising your bond in your case. It's currently set at $30,000. I'm going to raise your bond to $75,000. I'm going to order, as a condition of that bond, that you have a drug patch at all times, that you get it changed out as you're supposed to. Your case is still set for trial to begin with jury selection on Monday, and is everybody ready for that?
Yes, Fred.
State your name.
All right, I'll number the case. If you're in custody, we'll have you brought over for trial. If you're not, then you can talk to Mr. Kimmler this morning, okay? All right, you can go back with the bailiff. Mr. Kimmler, on Brianna Clanan, you can come up, Ms. Clanan. All right, Ms. Clanan tested negative, which is obviously good, and
No 5 hour energies.
yeah, you never know about those energies.
Stay away from
Ms. Clanan, in cause number 25, DCCR 0446, you were previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
defense agent.
Yes, Your Honor.
Are there any additions or corrections?
No from defense.
Not from the state, Your Honor.
What is everyone's position with regard to the recommendation in the pre-sentence report with regard to her addiction issues? The recommendation is ISF followed by JCDI program.
Again, from the defense, Your Honor, the treatment is a continuum, I suppose, and since she's demonstrated, at least today, that she's drug-free, then I would suggest the court hold the ISF in advance to just see how she progresses on probation. Maybe perhaps with a drop program.
Well, she's going to go through JCDI for sure. If, at a minimum. Mr. Nichols, thoughts since
I
she
would ask
tested
at least for
negative?
JCBI, Your Honor. She's still underage, but she has a drinking problem and needs to get that dealt with, treated, or under control. And she also smokes marijuana regularly. The facts on this case, she and her friend were heavily intoxicated,
Yeah.
fled from police, lucky it wasn't a crash,
It could have been terrible.
tried to hide out from police
Yeah,
around
I know, yeah.
it could have been a lot worse. And I'll just tell the court from reviewing the video, at least that night, they sure thought it was hilarious. She needs to grow up. She needs to take a little more serious what's getting her here in felony court.
Yeah.
And
You understand it's not funny. I mean, no, I understand that right now, and people do
But
that.
that night, yeah, I do regret everything that night.
So here's the thing, and the seriousness of this is that if you don't do what you're supposed to and get your life on the right track, which is what everyone wants. You're young. We want you to be successful. You're going to get a probation today where you don't have a felony conviction on your record. And if you complete that probation, you're never going to be a convicted felon. But if you violate and you don't take advantage of the programs that we're going to give you, it's going to be difficult because you're at an age where all your friends are going to be doing things that you're not going to be able to do. But the alternative is prison for up to 10 years. So you need to think about that every time somebody says, oh, just come on out with us and do whatever. And your answer is going to be, I'll do that in a few years when I'm not on probation, right? Because I don't want to go to prison for 10 years. So I am going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $250 fine. I am going to order that you enter and successfully complete the ISF substance abuse track, but I'm going to hold that in advance. That is an inpatient 90-day program. So if you get in, you're going to be required to go to JCDI and complete that program. And it'll give you the tools, hopefully, that you need to stay sober. If that's not enough and you need something more, it's already ordered. A warrant will go out for your arrest. You'll go into custody and you'll go straight to that program, okay? I'm handing you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck to you, ma'am.
thank you, Your Honor.
Thank you. I will. Good morning. Are you Steve Ray Williams? I need you to speak up since you have that. Are you sick? Okay. So, client waived the formal reading of the indictment in each case.
He does, Judge.
All right, let's get started. Mr. Williams, in cause number 26, DCCR 0312, you're charged with the state jail felony offense of unauthorized use of a vehicle, and that's from December 2nd of 2025. Your indictment alleges that you were previously convicted of possession of a controlled substance, a state jail felony, March 25th of 2002. And after that was final, you were convicted of possession of a controlled substance, a state jail felony, May 22nd of 2024. And how do you plead to that charge?
Guilty.
Speak up, please.
Guilty now.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I need you to answer out loud.
Yes, ma'am.
And are those prior two convictions true?
Yes, ma'am.
In cause number 26 DCCR 0313, which counts are we going on that case?
See.
I'm going to go back to the cause number ending in 0312. It's the one you just pled guilty to. It had those two prior state jail felony offenses listed in the indictment. The state has also filed a notice of intent to use prior convictions to enhance. And in that, they allege that you were also previously convicted of the second-degree felony offense of possession of a controlled substance. That conviction, again, from of possession of a controlled substance from July 30th of 2003, which was a first-degree felony. Is that true or not true?
Yes, ma'am.
And then there's also an allegation of a conviction from March 11th of 2008 that you were convicted in the United States District Court for the Eastern District of Texas of the offense of felon in possession of a firearm. And is that also
Yes,
true?
ma'am.
And so what that means is that for punishment purposes, in this case, the punishment range would be that of a second degree felony, which is between 2 years and 20 years. Is that your understanding?
Yes, ma'am.
And again, did you enter your plea of guilty and true to those prior convictions freely and voluntarily?
Yes.
All right. In cause number 26 DCCR 0313, you're charged with unlawful possession of a firearm by felon, third degree felony from December 2nd of 2025. The indictment alleges you were previously convicted of possession of a controlled substance, a first degree felony, July 28th of 2003. And then the notice of intent to enhance alleges that same prior that we already talked about, which is the felon in possession of a firearm case, which was the federal case from March 11th of 2008. How do you plead to this charge?
Guilty, ma'am.
And again, are those prior convictions true?
Yes, ma'am.
And did you plead guilty and true freely and voluntarily?
Mm-hmm.
And in this case, that makes the punishment range that of a habitual offender. Is that everyone's understanding?
Yes, Your Honor. Yes, Your Honor.
Then, in cause number 26 DCCR 0314, you're charged with the second degree felony offense of abandoning or endangering a child within placing them in risk of imminent bodily danger. And that's a second degree felony from December 2nd of 2025. And how do you plead to that charge?
Guilty, ma'am.
And then that indictment also alleges that you were previously convicted of possession of a controlled substance, a first degree felony, July 28th of 2003. In addition, that notice of enhancement alleges that prior conviction of felon in possession of a firearm, making this habitual punishment. Do you understand?
Yes, ma'am.
And again, are those prior convictions true?
Yes.
Cause number 26 DCCR 0315, you're charged with the state jail felony offense of theft of a firearm. And that's from December 2nd of 2025. That indictment alleges those prior state jail felony convictions, the possession of a controlled substance from March 25th of 2002. And then after that was final, the state jail offense, possession of a controlled substance from May 22nd of 2024. In addition, there's the two prior felonies that are listed in the notice of enhancement, the felon in possession of a firearm, as well as the possession of a controlled substance, which was a first degree felony. And how do you plead to this charge?
Guilty, ma'am.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And also, are all those prior convictions true?
Yes.
And then finally, in cause number 26 DCCR 0316, you're charged with a first degree felony offense of aggravated kidnapping from December 2nd of 2025. And how do you plead to that charge?
Guilty, ma'am.
And that alleges in the indictment the prior offense of possession of a controlled substance, a first degree felony, July 28th of 2003. In addition, there is the notice to enhance that alleges the prior felon in possession of a firearm from March 11th of 2008. And are all of those prior convictions true?
Yes, ma'am.
And that for punishment purposes makes this a habitual offender, correct, everyone?
Yes, ma'am.
Did you enter your pleas of guilty and true in all of these cases freely and voluntarily?
Yes, ma'am.
And did you plead guilty in each of the cases because you actually did what they've charged you with?
Yes.
In all of these cases, I have here on the tablets and documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney in each case that you'll be waiving or giving up any right to appeal?
Yes.
So is it 20 on the 2
State jails.
and 35 on all the others?
That's right, Judge.
Right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty and true, freely and voluntarily. Find again you're mentally competent and understand the nature and the consequences of all of those pleas. In cause number 26, DCCR 0312, find sufficient evidence to find you guilty and find all those counts true. And in that case, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
In cause number 26, DCCR 0313, find sufficient evidence to find you guilty, find those prior counts true, and at this time find you guilty of unlawful possession of a firearm by felon, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0314, find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child, find those prior convictions true, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0315, find sufficient evidence to find you guilty and find all the prior convictions that you pled true to true. And at this time, find you guilty of theft of a firearm, find those convictions true, find, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in clause number 26, DCCR 0316, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated kidnapping, find those prior convictions true, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these cases will run concurrently, which means together at the same time, handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, and you obviously know this because it's one of the charges and you've had the charge in the past, but I'm required to read this to you by law. So because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lewis. All right. Good luck to you, sir. You can go back with the bailiff.